Hello, everybody. I wanted to outline the steps that we follow when we have a new case and a new client comes in, and I want to explain what happens after we complete the intake process. I am your attorney, Neil Redmond, and the first thing that we do is that we look at your case and figure out who we determine are the responsible parties, otherwise known as the eventual defendants. And those are the parties that we're going to be suing. So the first thing that we do is we write a letter to them, putting them on notice of the fact that we're going to be suing them, and to tell them to establish a claim and to send that claim to their insurance company, at which point we will hopefully receive back a letter from the insurance company with a claim number and a claims examiner, also known as a claims adjuster, that we will communicate with and try to establish a rapport and possibly settle the case early on. However, that normally doesn't happen. They usually want to get more information in terms of finding out how the incident happened and what injuries were sustained from that incident, accident, or medical malpractice. And so we'll send out a letter to the claims department trying to set up what we believe are the reasons that we feel their client is responsible. We'll also send out a letter initially to you, our clients, thanking you for being a client of our law firm and letting you know who to call and who to talk to if you have any questions. After that, we'll also file a document called a no-fault document with any kind of motor vehicle involved accidents. And we will also request from all the medical providers that they give us copies of all your medical records. If there was an ambulance trip involved, we'll get that from the New York City Police Department. If there's an emergency room visit, we'll get those records from the emergency room, as well as whatever therapy or MRI reports are necessary that would help demonstrate what injuries you have and how they're related to this particular incident. After that, when we get some correspondence going between us and the insurance company for the defendant, if they're not willing to settle, which most of the times they're not, we'll go ahead and file a document called the summons and complaint. And that is the thing that initiates the lawsuit. We usually don't do that for about 6 months because we are trying to establish a rapport with the insurance company and try to get them to settle the case. After we file that summons and complaint with the court, then we have 90 days to serve it upon the defendants. We usually try to do that immediately. And then they have 30 days to respond with their answer. And after they complete their answer, we do a document called a bill of particulars. And the bill of particulars spells out all of your medical injuries and how they relate to the accident. It's quite a complicated document with numerous different parts to it. But when we serve the bill of particulars upon the defendant, their lawyer, the next step is for us to schedule a preliminary conference with the court. And that is the conference where we set up the depositions and we move the case along to the next phase. At that point, we're going to be doing depositions of all of the parties. That includes you, at which case you'll be asked questions by the other lawyer about what happened, what caused the incident, and how it's affected you. And of course, I will prepare you for that, or one of my attorneys will prepare you for that, and we will be with you during the deposition. Then I will take a deposition of the defendant and fight with them about what they're claiming happened. After the depositions are done and all of the paper has been exchanged in terms of any reports and documents that are relevant to the case, the next thing we do is we put the case on the trial calendar. Once we put the case on the trial calendar, it takes at least 3 to 6 months to get our first pretrial conference. And after that, we'll continue to go and conference the case with the eye towards settling the case. If we cannot settle the case, then we do the trial. So that's the case in a 5-minute nutshell.